the CEO of the Idaho Medical Association, and I'm joined by my great colleagues, Jamie Neal, who is the IMA's Director of Government Affairs, and Lisa Carlson with Holland and Hart, to whom we are very grateful for all of her work and effort in helping us learn about the Idaho Patient Act. I would like to thank all of the IMA and IMGMA members who've completed surveys and really just helped inform our work so much in grappling with this act, the Idaho Patient Act, or IPACT as we call it sometimes, and trying to make sure we can comply and identifying those things that are really problematic and hopefully push for changes. So we'll talk more about that later, but for now, we'll get things going, and I will turn it over to Lisa Carlson, who's going to walk through the various technical aspects based on the questions that you've provided to us. So I also want to mention, if you have questions as we go along with certain provisions of the Act that we are discussing, please go ahead and post those in the chat, and we'll relay those and answer them to the best of our ability. So with that, Lisa, I'll hand it over to you.
Awesome. Thanks, Susie and Jamie. You guys have been so incredibly helpful, and we all owe you a debt of gratitude for the valiant efforts that you and others in the healthcare industry are making to champion for some much needed revisions and clarifications to this act. I will refer to this as the Act because I'm lazy and I don't want to refer to it as IPACT or Idaho Patient Act. But with this Act, yeah, you've made some great progress, and for that we are grateful. So as Susie mentioned, the format of this presentation is going to be a brief overview of the requirements of the Act. I did do a previous presentation that is a recorded webinar back in September that goes into much more nuanced detail about all of the different components. And if you would like the link to that webinar recording, feel free to email me, and my email information will be available at the end or is available on the Holland and Hart website. So certainly can provide you with that information as well. So, and then also, as Susie mentioned, if you have questions, I see there's more attendees coming on the line, so I want to just repeat it. If you have questions as we go, there's a Q&A or a chat feature in this webinar, so feel free to type in your questions. If we can't answer them because they're too hard, or we just run out of time, or they're too nuanced to maybe your practice, we will certainly circle back with you and get those questions answered for you. So as everyone is well aware, the purpose of this act is to protect patients from aggressive collections by imposing transparency in the medical billing process. That's sort of my high-level summary of why we're here and why this bill transpired. The problem is that there's some consequences that stem from the implementation of this law because it places a lot of obligations on healthcare providers, particularly if they want to preserve their ability to collect on any outstanding medical debt from their patients. So on this first slide, I've highlighted who must comply. So that's a really important element. We get that question a lot, like, does this even apply to me? So this law applies to any healthcare provider that wants to engage either directly or indirectly in any extraordinary collection action. And the reason that those terms are underlined and bolded is because they're defined terms, which means that the statute specifically tells you what they consider to be a healthcare provider. So I have those definitions here. So a healthcare provider is a physician or other healthcare practitioner that's licensed, accredited, or certified to perform healthcare services consistent with state law, or also includes an agent or third-party representative of one of those healthcare physicians or healthcare practitioners. A healthcare provider is also a healthcare facility or its agent. Healthcare facility, again, another defined term, a person, entity, institution operating a physical or a virtual location that holds itself out as providing healthcare services. Now, healthcare services is, again, a defined term. It's services for the diagnosis, prevention, treatment, cure, or relief of a health condition, illness, injury, or disease. So if you are not a healthcare provider or a healthcare facility, as those terms are defined, or you're not providing healthcare services, arguably the act does not apply to you. Additionally, if you have no intention of pursuing an extraordinary collection action, the act may not apply to you. So we'll move on. So what is an extraordinary collection action? And that's important. So an extraordinary collection action, or ECA, as I will likely refer to them throughout this presentation, is a very specific set of actions that would be taken by a healthcare practitioner. So prior to 60 days, prior to 60 days from the patient's receipt of a final statement, it is the selling, the transferring, or the assigning of any amount of the patient's debt to a third party, or otherwise authorizing any third party to collect a debt in a name other than the name of the healthcare provider. Now you see that I have highlighted that. That is a really important distinction as to when a use of a third party may be considered an extraordinary collection action. So if it's in the name of the healthcare provider and that debt is not ever transferred, sold, assigned, or otherwise authorized to be collected in that name of that third party, you may be within the realm of it doesn't constitute an extraordinary collection action. We'll talk about that more in a bit. That's one of our FAQs. On the other element that constitutes an extraordinary collection action is reporting adverse information about the patient to a consumer reporting agency. So if you're reporting them to a credit reporting agency, that constitutes an ECA. And third, an ECA is commencing any judicial legal action or filing or recording any document in relation thereto. So it's meant to be broad. So any legal action, just think legal action that's related to that debt. So placing a lien on that person's property, attaching or seizing their bank accounts, initiating a civil action, so suing them, or garnishing their wages. So any of those actions will constitute an extraordinary collection action. So if you want to pursue one of those three, you have to comply with all of the elements of the act. So the way that makes the most sense, and that I've seen anyone who tries to explain the Idaho Patient Act, the best way to do it is to break it down into the series of steps that are required in order to comply. So step number one would be to submit the charges. Now, the Act specifically states submitting charges. I think the common understanding is we're talking about submitting a claim. So step one, the patient receives the goods or services from the healthcare facility. That would be your date of service. Then within 45 days of the provision of those goods or services, or if you're in a facility type where you have patients that are inpatient, so 45 days from the date of their discharge, the healthcare provider must submit charges to the third-party payers that are identified by the patient. Now again, a bolded underlined term means that it is a defined term. A lot of questions come in about what constitutes a third-party payer, and it's a defined term, and it's really limited to, and I'm looking at my definition over here so that I don't misspeak, but it's really intended to be a health carrier as defined in the insurance code, or a self-funded plan as also defined in Idaho Insurance Code. So we're not talking about medical sharing plans. The other element is if the patient does not identify a third-party payer, you're going to be submitting those charges to the patient. So in those circumstances, where they haven't identified that third-party payer, or they identify that medical sharing plan, you have discretion there to submit the charges to either of those parties. So going straight then into the FAQ. So wanted to address questions that are specific to step one. So number one, when does the 45 days start for patients receiving a series of medical treatments that are billed together? And this is probably the most common question that we have, and also one of the hardest to answer. because as written, the Act requires the submission of charges 45 days after the date of service or discharge. So although this may not be consistent with third-party payer processes or their claim submission requirements or their contractual requirements that you may have with those third-party payers, particularly for services that are billed globally, strict compliance with the Act would require submission of those charges 45 days after those services are rendered to the patient. So on question 2, and I actually backing up to question 1, I know this is an area where Susie and Jamie are probably, they're going to address this later, but this is one that is very much, the topic of discussion. So I'll let Susie and Jamie talk about that a little bit more later. Number 2, does the Act require submission of charges or claims? Now, as I mentioned on the previous slide, technically the Act requires submission of charges. I think this is a perfect example of other elements within the Act where the terminology doesn't quite fit common medical practice. So even though the Act makes no reference whatsoever to a claim, which is the common nomenclature for submitting charges to a third-party payer, and it doesn't require any type of submission of a complete claim or a clean claim. Technically, the intent of the Act is to submit a claim, and so that is really best practice, what we're advising. However, if it came down to being challenged, it's questionable what a court would decide is meant by the term charge. What if the charges were submitted incorrectly and it's your error, but the error was noticed after expiration of the 45-day period? Now, this is one where it's likely that your submissions can be corrected or modified beyond that 45-day window as long as that initial submission was made within the 45 days. And again, it goes back to the question right above it, where the Act doesn't require any type of clean claim, complete claim, correct claim, accurate claim, it's claim. Again, the intent, of course, of most medical billing offices is to get it right the first time, because that means you're going to get paid a lot faster. So we know there's not going to be an intention of submitting an incorrect claim, but certainly if there's an inadvertent error, don't think that that would preclude the ability to pursue an extraordinary collection action if you correct it on day 47. On the final question there, it looks like it's getting a little bit cut off by the Holland and Hart very bold logo down there, so I apologize. But what if we learn only after submitting charges or providing the patient with the charges within that 45-day period that the patient provided incorrect information? So maybe they said that they didn't have insurance coverage, or that they didn't provide their secondary coverage, or they provided the wrong policy. One item is that you can rely on the information that's provided by the patient, even if it's correct, even if no payer information is provided. So if the patient says, don't have insurance, and you submit those charges within the 45 days to the patient, and they later come back and say, oh, just kidding, I do have insurance, or what, here's my policy, you still are well within the compliance of the Act as long as you provided the patient and you relied on that information that was provided by the patient and you submitted those charges appropriately within that 45-day window. Next question. So how does the 45-day grace period work? So in the Act, the Act provides that healthcare facilities have an extra 45 days to submit charges. So you have 90 days total following the provision of those goods or services. However, if you submit them within the first 45 days, then if you ever have to go to court, you get to recover fees and costs. If you don't submit within the first 45 days, but you submit, between day 46 and 90, you can still pursue an extraordinary collection action, but you'll be precluded from recovering costs and attorney's fees in that action. I guess I'll go ahead and answer it now just because it's related. I know it's not on here. If you blow both days, you don't do it within 45 and you don't do it with 90, can you still pursue the extraordinary collection action? Arguably, yes, you can. However, you can be subject to damages and fines. And so we'll talk about that a little bit more later. So what is the penalty for not submitting charges within either of those? Again, subject to fines and damages. And then are charges expected to be submitted within 45 days, even when there's not a policy active? So the question with this one that comes in frequently is in the case of newborns, where the infant does not have a policy in effect yet, and you're waiting on the insurance of the third-party payer to set that up and to provide a policy. So the plain letter of the law requires strict compliance with the established timelines following the date of service, regardless of whether that claim is going to be accepted or rejected. So if you know that there's a policy in place for the newborn, you may need to submit that policy, that claim, even though knowing it's going to be rejected by the insurer. If the parent, again, doesn't have any policy information yet, then you would submit the claim to the charges rather to the parents. So in this instance, multiple claim submissions may be required to accomplish reimbursement, and that would be similar situation with global fees as well, where you may be required to submit multiple times in order to accomplish that reimbursement.
Lisa,
Yes.
I just wanted to break in here. There's a question in the chat that you actually addressed with the first topic on this slide, but I just wanted to call that out for the person who asked the question. So it sounds like what they presented and their understanding is correct based on the information you provided. So just wanted to call that out.
Okay. Great, thank you. And I think we're moving on to step number 2. So is there anything that, I'll give you an opportunity, is there anything that you wanted to add before I speed along into the next topic?
Nope, not at this time. Thank you.
Okay. Actually, just kidding, there's more. I should know this. So are we required to submit charges to medical sharing entities? Again, I already addressed that. I guess I get ahead of myself a little bit, so excited. Are we required to submit charges to secondary and tertiary third-party payers within the 45-day period? The answer to that is yes. The Act specifically contemplates the submission of charges to third-party payer or payors of the patient. So if the patient identifies multiple payers, then charges should be submitted to each of those. And then we talked about a little bit earlier about the previous slide and the highlighted portion of what constitutes an extraordinary collection action. So one question that comes in frequently is whether healthcare facilities or providers are permitted to set up payment plans with patients prior to providing that consolidated summary of services or final statement. And we would say yes, as long as the debt remains in the name of the healthcare provider. So the prohibition and what constitutes that ECA or that extraordinary collection action would be the transferring, selling, or assigning of that debt, or allowing a third-party payer to collect that debt in a name other than the provider. So if you were to set up payment plans with the patient, you know anything that's completely within the realm of acceptability to take those individual actions to collect that debt. Okay, moving on to step 2, which is the requirement to send the consolidated summary of services. You'll also see on some of the slides that I abbreviated it as CSS, so don't be confused. So the requirement here is that within 60 days of the provision of goods or services, or in the event of an inpatient stay or discharge, the patient must receive a consolidated summary of services from the healthcare facility they visited. That's a highlighted portion because that's a common question that we have as far as who is required to comply with the requirement to send that summary. Now, there is an exception that's built into the Act, and that is where a healthcare facility that the patient visits, where they the patient will receive a final statement from a single billing entity for all of the services that are provided to the patient at that healthcare facility. Essentially, that means the patient's going to receive no other bill from any other entity, so they're not going to receive a bill from radiology, from a lab. They're going to receive only one bill, and it will be from that healthcare facility that they visited. They also, so there's an and, I've highlighted that as well, so you know that you have to comply with all three. The patient was informed in writing of the name, the phone number, and the address of the billing entity. And then the healthcare facility complies with the other statutory provisions, so submitting the charges and providing that final statement. So the consolidated summary of services is a defined term under the Act. By being defined, it includes very specific elements that must be included in order to comply with the Act. So these I've outlined these here. I don't want to necessarily read through all of them because in the interest of time, and I will address many of these in the FAQs here in a bit. But I did highlight the general description of goods and services because that's a common question. So just note that, and we'll address that here in a second. The consolidated summary of services also must have the label that's there at the bottom that's circled, indicating that it's not a bill, it's a summary of medical services you received. Retain it for your records, yada, yada. It has to have that in order to comply with the Act. There's no requirement that it be in any type of format or that it be mailed or it can be e-delivered. So there's a little bit of flexibility there. So a lot of practices I've been informed are providing the consolidated summary of services to the patients in person immediately following their visit, or they're providing them via email or their patient portal, as long as they have the appropriate consent to provide those to the patients via those, via those methodologies. And then, of course, you can send that via regular first-class mail. On that second question, how does the 3-day mailing presumption factor into the 60-day timeline? So in the Act, the requirement is that the patient receive certain notices, and the summary of consolidated services is one of those where it must be received within that timeline. So we've got 60 days. The patient must receive the consolidated summary of services. So if you mail it, if you hand it to the patient, obviously they've received it. You can date and you can get an acknowledgement signed by the patient that they've received that consolidated summary of services on a particular date. It'd be really easy that way to demonstrate that they've received that summary. But if you mail it, it's a little bit difficult to ensure that they've received it. So there's a presumption, and the presumption is that it will be presumed that the patient receives it 3 days after mailing by first-class mail. So because the timeline is built in such a way where the patient has to receive it within 60 days, you need to mail it before 60 days. So you at least need to mail it by that 57th day in order to be able to rely on the presumption and hit that deadline of the 60 days. On the third question, how does the 90-day grace period work? So similar to submitting charges and how there's the 45-day additional built-in, grace period to submit the charges, you can have an additional 90 days to ensure that the patient receives a consolidated summary of services. So you've got 150 days total. However, just like the other grace period, if you rely on that 90-day grace period, you will be precluded from recovering costs and attorney's fees in the event that you pursue an extraordinary collection action where fees and costs are at issue. On the fourth question, what if the consolidated summary of services sent to the patient is incorrect? So the issuing healthcare facility should correct any errors or omissions within the statutory timeframes to be able to pursue or to preserve their ability to pursue an extraordinary collection action. So that's another one where, you know, by nature of the definition of the consolidated summary of services, you are communicating certain information to that individual, and that information should be correct. So what can a downstream provider or entity do if the healthcare facility that the patient visited doesn't issue a consolidated summary of services, or if they accidentally or intentionally, hopefully not intentionally, leave the downstream provider off of that consolidated summary of services? Unfortunately, this is another one where the Act doesn't provide a lot of flexibility here. So it's really up to the downstream provider or entity to work with the upstream provider that has that obligation to provide the consolidated summary of services. It's up to them to work together to correct the omission in that consolidated summary of services within the statutory period in order to preserve the right of that downstream entity to pursue the extraordinary collection action. So as a medical clinic or a solo provider, when am I required to send a consolidated summary of services? I think I addressed that earlier, but just because it is a common question, so it's the facility that the patient visited. That's the facility that has the obligation to provide that consolidated summary of services, but only where they will also receive a bill from another billing entity for goods or services that were provided to the patient by other healthcare providers while they were at that healthcare facility. So I will use the exact example that was used during the committee hearing testimony. So patient visits a facility, they have their blood drawn and sent out to the laboratory. The laboratory bills separately. In that situation, the facility should include information about the lab on the consolidated summary of services provided to the patient. And they would have that obligation to provide that summary. And what if a consolidated summary of services is returned to the provider facility as undelivered? So this is another area where it's problematic because the Act only establishes a presumption of receipt, that the patient received, you know, the requirement is that they receive that consolidated summary of services. And there's a presumption that they receive it 3 days after you mail it. But if you get it back saying it's undelivered, that eliminates the presumption that they received it. So the burden is on the provider to meet and show that they've complied with the statutory obligations in order to pursue that extraordinary collection action. So in that circumstance, it would be the obligation of the provider to, for lack of better phrasing, track down the patient and provide them with a consolidated summary of services within the statutory periods, or it could impact their ability to pursue that extraordinary collection action. Okay, what constitutes a general description? So remember, I highlighted one of those portions, says a general description of goods and services provided to the patient. I get that question a lot. What is a general description? Well, there's no definition or context within the Act, so it's really hard to infer an interpretation of what's going to be good enough as a general description. So in those circumstances, and if you were to go before a court, generally the judge is going to give those words their ordinary meaning. So in this circumstance, the best advice I generally have is, what do you think is a general description? Is it something where the patient will be able to identify the goods and services that they received? So if it's sufficient enough that they can understand what it is that they received, it's probably going to suffice on the consolidated summary of services as a general definition. So what is duration, and how does it apply to an outpatient clinic? So again, this is one of those requirements that you have to include on the consolidated summary, that you have to give the duration of the patient's visit. So it's not defined, so and it's generally not used in outpatient clinics. So giving this word its ordinary meaning would be to give the length of the visit, even in an outpatient setting. So but again, open to interpretation here. If a practice does not have to provide a consolidated summary of services due to there being no outside billing, how must the practice satisfy the requirement that the patient be clearly informed in writing of the name, phone number, and address of the billing entity? So again, one of those common questions, there's many different ways to satisfy this requirement. Folks have asked, can we just post something at the front desk that shows that, this is going, can we put it on our patient registration or our policy document? In certain circumstances, that may be appropriate. The phone number requirement would generally be satisfied through the final statement. So they would be clearly informed of that requirement there, but otherwise there's just no specific methodology required for how to provide that information. So in those circumstances, it's generally what makes the most sense for integrating into the current practices of the facility. Okay. Can providers use a standard statement in their financial policy or registration form alerting patients that if they receive labs, they may be billed separately by XYZ lab or whatever other downstream entity you have that's providing services on behalf of patients when they visit your facility? The answer to that is unfortunately no. The Consolidated Summary of Services has very specific elements, information that is going to be specific to each visit, including the date and duration and the general description of goods and services that were provided during that visit. So it just wouldn't be sufficient to put some type of general disclaimer or information language that the patient will be getting a bill from another outside entity. That doesn't mean you can't tell them in multiple places so that there's no confusion, but it certainly would not satisfy the requirements of the Act. And then the final question on this step 2 is, if the patient receives their final statement within 60 days of the date of service, must the facility still provide a consolidated summary of services? And the answer to that is yes. Unless the healthcare facility is exempt from having to provide that consolidated summary of services, they must still provide the consolidated summary of services and the final statement under the language of the Act. And in part, if you have the obligation to send the consolidated summary of services, it's likely because there's going to be downstream billing entities as well. And so that final statement would not include information that would be required in order to preserve those downstream entities' ability to pursue that extraordinary collection action. And I just made a little note that says many providers are providing that consolidated summary of services in alternate means, in alternate ways, either through an after visit summary page or through a patient portal in order to be able to save postage. So there's certainly options there if cost savings is important, which I know it is. Okay, so are there any questions in the chat or any other comments you'd like to address?
So there were actually a handful of questions that addressed the last portion of step 1 with respect to multiple payers, and questions about, okay, we don't even know we have to bill the secondary payer until after the primary payer comes back to us, and what if the timelines are gone, have passed by that time? So a handful of questions about that.
So as far as not knowing about the secondary payers until after the timeline has passed, that falls squarely within the you only have to rely on the information that's provided to you by the patient. And so if you're submitting that those initial charges within the 45 days based upon the information that was provided to you by the patient, I would think that would be sufficient under the Act for and then you learn more information later, or you get updated information from the patient. As long as you submitted those initial charges within that first 45 days, then you should be okay.
And for those circumstances in which maybe the primary, there's a secondary payer and the primary payer doesn't get back to you within the 45 days, then that puts the practice in a bind, unfortunately.
Certainly.
And then there are several questions with respect to the CSS. Um, so this one says, we're a small practice and been giving out the CSS when patients check out from the appointment to save time. Is this okay?
Yes, as long as it has the required elements. It doesn't matter how you give it to the patient as long as they receive it within the period of time.
And what documentation does a practice need to keep as proof that they sent the CSS to the patient or hand delivered it to them?
So, there are different, different documentation. There's nothing that's required. Let's just lay that out there. It's going to be best practices. So depending upon how you provide the CSS to the patient. So I would advise best practice if you're handing it to the patient is to have some type of electronic signature or a signature log where they're acknowledging that they receive a copy of that CSS and then keeping that in their medical record or their billing record, depending again on how you manage your records. If you're mailing it to them, you need to have general policies and processes in place. So, you have to have a policy that says this is how we generally handle this. We followed our policy to the extent that it's hard with if you're hand addressing or printing out and sticking a stamp on something, you definitely want to just keep notations in your file when you're sending out those summaries to the patient and the methodology that you're using. So if you're using USPS, then you're going to need to keep the date that it was sent and the address to which it was sent and who processed. Best practice to be who mailed that out and when.
Okay. This is a big question that a lot of practices grapple with. How do you know if you've been excluded from a CSS? The Act contemplates some additional time to address that, but how do you know if you've been excluded and what do you do?
It's a really great question. I think you know that you've been excluded from the CSS when it comes time to file that lawsuit and you want the documentation because you have to be able to, before you file, you have to meet certain burden of proof. And so I think that's when you find out. And unfortunately, that's a little too late.
And,
I don't know, do you have other thoughts in your conversation, Susie? I know this is a very contentious topic.
Yeah, this is a real problem because I think for most practices, they don't know that they've been excluded from the CSS until they are trying to get payment out of the patient and there's resistance there. In fact, some patients may even go so far as to say, oh, I've got a get out of jail free card on paying my bill because you didn't get yourself on the CSS. So this is one that we are really working to see if there are some elements to redress that and hold the practice harmless that's been excluded. But right now, the answer to that question is be in constant touch with the facilities at which the physicians practice and just make sure. I know right now that makes a lot more work on behalf of the practices, but I think that's the best way to probably cover it. And again, this question, if you're seen in a private clinic and they will only receive a bill from you, is a CSS still required? I can answer that one. The question is no. So Lisa did a good job of handling those exemptions. Here we go. I understand that the CSS needs to be provided to patients for goods or services received in the clinic. What about orders for future dates? For example, provider completes an order for the patient to have labs drawn in 30 days, but the patient does not get the labs drawn in the office, but goes to a separate lab and has the labs drawn there. Do we need to add to our CSS that we provide to the patient at the time of their visit when the doctor ordered the test, but the test is not completed at that time?
So the answer to that would be no. The obligation is on the healthcare facility where the patient visited. So in that circumstance, even though the provider is issuing the order, the patient is physically visiting the lab to have the labs drawn. The lab is going to issue the bill. So there's no obligation on the medical provider to include that on their consolidated summary of services.
Okay, and just to make this extra interesting, we have questions going in the chat, and we have questions going in the Q&A. So
Yep.
we're kind of bouncing back and forth. I'm going to look through here and see questions with respect to the CSS. So our office uses multiple labs. Are we required to be specific, or can we list all potential labs on the CSS, and then I'm assuming just mark which one pertains to the patient at that time?
Right. I think if you know in advance where you're going to be sending the lab, certainly the CSS, there's multiple ways you could structure that. You could have it where it lists all of them, and then there's a checkbox next to the one that the patient could expect to receive a bill from. I think my general advice would be to be as specific as possible in order to comply with the Act, as far as identifying the lab from which they're going to expect a bill.
And I believe this question has been addressed, but we'll just go ahead and call it out to give confirmation. It says, we are a dental office. If we refer a patient to a provider outside of our practice for treatment, do we have to provide a CSS listing for that outside practice? And I'm assuming that's for services to be done at a future time.
Yeah, so if you're just making a referral and then the patient is going to go to that other provider and they're going to receive services there and be billed from that provider there, then no, there's no link between the providers just by nature of making that referral.
Okay, what happens if we are unable to reach the patient to get the CSS? Whether it be they gave us the wrong address and phone number, or we have tried every method to try and contact them and are unsuccessful.
Yep, I think you've identified one of the problems where, yeah, I mean, the obligation is on the provider to make that contact and provide that information to the patient. I think one of the biggest things that they addressed in the committee hearings was how unfair it was with all these patients coming with that had never received a bill and had no idea that they owed any money and were getting hailed into court. So I do think that was one of the issues that they were trying to address by saying, you need to make contact with your patients. So.
Okay, and I'll hit this one last one that I can see right now. I know some others have come in on the other chat function. Can you explain again what allows the additional 90 days in submitting a CSS to the patient? If we determine we want to send a patient to collections, are we able to send a CSS at that time and still be compliant?
So as long as you are within the statutory period. So if I'm understanding the question correctly, it's, can you wait to provide that consolidated summary of services? There's 2 points to that. Number one, do you have anybody downstream that's going to be upset or that you've contractually obligated yourself maybe to providing that consolidated summary so that they can preserve their ability to pursue an extraordinary collection action? So maybe you've already got that worked out. The second part would be if you want to not provide that consolidated summary of service until you're sure that you want to pursue the extraordinary collection action, then yes, you have a full 150 days to provide the patient with a consolidated summary of services. The difference being that if you are somewhere at between 61 and 150 days, you don't get to collect any costs or fees if you for example, if you take them to court, you won't be able to collect attorney's fees or court costs for those actions. Okay. And should we maybe move on and save some of these questions so that we could get to the other FAQs?
Yep, these are great questions. And there's also some questions about, will these slides be available? And it's my understanding this webinar is being recorded, so we will be able to share that out. And if we are not able to address your questions during the webinar, we will work together to get some answers and have them either posted with Holland and Hart or IMA, because I know we can't always tell who the questions are coming from. So yes, Lisa, we'll let you move on.
Okay. Not that I don't like the stump the chump session, but we do want to hit the final step. So the final step then is to send the final statement. And again, as you can see, patients must receive. So there's your keyword. They must receive that final statement from the healthcare provider. And final statement is a defined term, so it has very specific elements that it must include, and I'll address those on the next slide. So then once the patient receives that final statement, the healthcare provider may not charge interest until at least 60 days have passed. So if you mail it on day 1, you can't charge interest until day 63 if you're mailing it by first class mail, because of that, again, that 3-day mailing presumption. Then you have to wait at least 90 days until you pursue an extraordinary collection action. So again, 93 days after you mail the final statement. So the final statement has to include, like I mentioned, very specific information, contact information, the list of goods and services that were provided, including initial charges for the goods and service. It also has to list on number 5, the name of the third-party payers to which charges were submitted, and the patient's group and membership numbers. So I won't go over, just in the interest of time, I notice we only have about 14 minutes left, so I won't go over all of the requirements of the final statement. Just know that it is in the definition section of the Act, which is Idaho Code 48303, in case you want to look that up. So getting into the FAQs, so when must the final statement be sent to the patient? So there's no actual correlation between the date the goods and services were provided and the date the final statement must be sent. Obviously, it's going to be in the medical group's best interest to submit that final statement as soon as possible, and particularly where they want to be able to start charging interest or want to be able to preserve their ability to pursue an extraordinary collection action soon after, as soon as they're legally able to. What if a patient disputes or is appealing the amount owed? So the Act specifically contemplates that you have to wait either the 60 days for interest or 90 days for an extraordinary collection action, or until the resolution of any appeal, review, or good faith dispute, whichever occurs later. So if you get to that 90 days and their patient is still contesting or maybe appealing with their insurance or appealing with you, whether the amount charged is correct, you have to wait until that is resolved before you pursue either charging interest or an extraordinary collection action. Now, what if the amount owed is adjusted following the submission of a final statement to a patient? So I do have a little note to myself to confirm that, but it is confirmed there's no obligation to send an updated final statement for pursuing extraordinary collection action. So obviously, there could be circumstances where a patient, maybe you send a final statement and then a patient sends in $100 toward their fee. So the question is, now does the clock restart, for example? Do you have to now send another updated financial statement showing that partial payment being made or maybe additional money received from the third-party payer? Do you have to then wait? Does the clock restart before you can pursue that extraordinary collection action? And the answer to that is likely no. What's the difference between a final statement and any other statement sent to a patient? So the final statement is, this is such a common question because the final statement is so final. It's really not the final statement. It's really the first statement. But under the Act, you can send any correspondence to the patient in the interim between the time that they receive goods and services and the time that you decide to send the final statement. So you can send any statement about the charges that they are expecting or the services that they received or what their amount owed is. There's no prohibition on communicating with the patient regarding services rendered or amounts that they owe. But the final statement requires very specific elements, and then it starts the countdown for when you can start charging interest or pursue that extraordinary collection action. So it also doesn't mean that it has to be the final end-all statement. You can also send additional statements after you send the final statement. As long as you did comply with the act by sending a final statement that has all the requisite elements, you're good. I feel like I made that one really confusing. So how many statements for a final balance must be sent before an account can be sent to collections? So again, only one fully compliant final statement must be received by the patient before sending to collections. Can the final statement be emailed to patients, assuming that you have the appropriate consent? And the answer to that is yes. There's no requirement on how the final statement is sent, only that it be received by the patient. So one element, and I know we talked about this earlier, is consider how you're going to ensure that the patient is receiving that statement. So my recommendation is always to build into any patient visit confirmation of their current contact information so that you're constantly getting the most up-to-date information about, or at least a verbal confirmation that the information that you have on file is current. What if the EMR does not have the capability to include the information that's required for the final statement? So because the final statement is a prerequisite to charging interest or pursuing an extraordinary collection action, one approach is to manually issue final statements only for those patients where an extraordinary collection action is desired. So if you simply don't have the capability through your EMR to issue a fully compliant final statement to your patients, maybe pursuing an extraordinary collection action or charging interest is more of a one-off type situation, and you'd only reserve that for larger balances. Certainly, providing that final statement only in circumstances where you intend to pursue an extraordinary collection action is an option. Maybe not a great option, but it's an option. What if a CSS, and that should really be a final statement. Again, what if a final statement is returned to the provider facility as undelivered? It's the same answer as for a consolidated summary of services, hence the typo. The Act only establishes the presumption of the 3 days. So if the mail's delivered, if it's returned undelivered, then your presumption is out the window, and you need to figure out how to get that final statement to the patient prior to pursuing the extraordinary collection action. One other element of the Act that's required for the final statement is reasonable detail. So again, we're going to look at the ordinary meaning of those words because that's not defined within the Act. Must the final statement be labeled in any particular way? No. Unlike the CSS, where you have to have that disclaimer language, there's no requirement that the final statement be identified or labeled in any particular way. It just has to contain the specific information. And now I left this in here just for your information. It talks about the fees and costs cap, particularly where you're pursuing a civil action, just to show, what types of fees are you talking about walking away from if you rely on the grace periods. The fees aren't a lot. If you have non-contested, you're talking $350. Contested judgment, $750 if you prevail. So the fees and costs are not a lot, and that was one of the purposes of the Act, was to not have the attorney's fees and costs be so disproportionate or outrageous, particularly in comparison to the principal balance owed by the patients. So with that, though, Susie, I will. I guess there's a couple extra questions just on the extraordinary collection action generally. If we don't want to pursue an extraordinary collection action, then unless you have another provider downstream, you don't need to comply with the Act. As far as providing that consolidated summary of services, if you have other providers, then you may need to comply for for their purposes. Consequences of pursuing an extraordinary collection action without strict compliance, there's penalties. So if you don't comply, doesn't mean you can't bring them to court, but it does mean that you can get hit with fines and damages that are incurred by the patient. And if you willfully don't comply with the act, those damages can be substantial, so 3 times the damages of the patient. And if you don't use a collection agency, we addressed this a little bit earlier, if you don't assign, sell, transfer the debt to a third party, you don't need to comply with steps 1 and 3 of the act. But again, consider whether you should be providing that consolidated summary of services. Let's see, a question about DME suppliers. Not considered a healthcare facility or healthcare provider, as those terms are defined. I think we already addressed if the patients dispute or are appealing the amounts owed. And then we'll just talk briefly about the time extension. So the time extension gave providers for services that were rendered prior to July 1st of 2021, you had an additional time period to comply with the act. So for services that were rendered prior to July 1st, you still have to comply with the act if you want to pursue an extraordinary collection action. You just aren't barred by the time limitations. So you still have to comply with the act for any services before, but now as of July 1st, any services that are provided after that date must comply with the time limits, the 45 days for submission of charges, 60 days for the consolidated summary of services. And I'm not going to spend time on the final considerations because I really addressed all of them as we went. And then I want to give Susie the final minutes to talk about the continued lobbying efforts.
Great. Thank you so much for that useful information, Lisa, and thank you all for your questions. We do have these documented. We will circle back and answer every question, and I think through the registration mechanism, get those out and email them to everybody. Just wanted you all to know we have been meeting with Melaleuca representatives since April and looking at all of these things. So some of the issues have been addressed. In the interest of time, we won't go into a deep dive on these, but there have been some that have been highlighted, and we are working on fixes for those. The issue of global fees has come up, and right now, if the insurance company doesn't allow you to bill for until the completion of services, which is after the 45 days, you can't comply with the Idaho Patient Act. So we're trying to fix that. Jamie, would you like to quickly touch on the others, and we'll wrap it up?
Being left off of a CSS inadvertently, if you're a provider at a facility you're not actually physically located at normally, when they send that bill, if you're inadvertently left off, we've proposed a solution to say, let's correct the CSS and restart the clock. That's something that we're pushing very hard for and hoping to address in the coming weeks and months in negotiations. On the final statement, the information that needs to be included is obviously very burdensome. The member number and the group number has been identified to us as a huge barrier to getting those compliant final statements together. So we're working to eliminate those 2 aspects of the final statement. We also see that as a privacy concern as well, because the Department of Defense and Health Administration, sometimes it's your Social Security number that's on that statement. So having that going out through the mail is obviously problematic and a privacy concern for patients. So another issue we're trying to address to kind of bring some of the financial burdens away from the final statement. The next slide has. So I know we talked a lot about, and I saw a question in the chat about reporting to a credit bureau. That's within the definition of extraordinary collections actions at the moment. That's a definition we're looking to amend in our negotiations by saying reporting to a credit bureau is, should be allowable and outside of and help you prevent from having to pursue legal action down the road. So that's certainly something we're looking at right now. Another issue is the bounce check issue. when a patient passes a bad check, we don't feel it's fair for the provider to have limited opportunities for recourse under the Idaho Patient Act if they can't collect the cost of their services. And then lastly, exempting outpatient clinical services from the requirements of the Idaho Patient Act. As Lisa addressed very thoroughly throughout the process or throughout the presentation, is that CSS is not applicable if you're a single billing entity. So the law has already acknowledged that there's some burden there if you're a single billing entity. So now we're saying, hey, maybe the whole act doesn't not need apply in these certain scenarios. So that's something that we're working very heavily on. And another issue that was, I think, identified throughout that was good and brought to my attention is that secondary payer not being able to be billed until the primary payer responds. And that sometimes is outside that 45-day window. So I'm glad you folks brought that up, and that certainly helps direct us on some of the issues we need to solve. And I'm glad that we had this opportunity to hear from you guys and want to continue to hear from you guys as issues come up. So with that, I'll kick it back over to Susie and Lisa and wrap this hour-long presentation up.
A lot of information in just an hour, and I know we haven't answered everybody's questions, but we are dedicated to making sure that we give you all the information you need to comply to the best of your ability while we continue to make that easier for you. So Lisa, any last thoughts from you?
No, thank you so much for this opportunity. It's been, yeah, like you mentioned, Jamie, it's been very eye-opening to have immediate feedback from the practices and the providers to be able to really hone in on the most important issues. So thank you.
And just to clarify, Lisa, I think Holland and Hart probably has a mechanism of all those that have registered. We have your email addresses, so we will start to work on getting those questions answered for you, and we will turn that around to you all. So thank you for your participation and your support of our efforts.
All right, thank you, everyone. Thanks for joining.